So, welcome again to LiberalViewer First Wednesday Live Q&A. This is my live show I do at 4:30 p.m. Pacific Time on the first Wednesday of every month. I think everything's working here. I'm going to answer several questions that people asked before I started the show. I really appreciate when people ask the questions beforehand so I can have a chance to do a little bit of research, because I think when I have a chance to do a little bit of research, I can give a lot better, more informed answer to the question, especially legal questions, which is what I've been seeing a lot of here today. So I'm going to get right to, I think I have like 5 or 6 questions that people asked. I noticed one person, Leo G, who hopefully still over there in the comment section, asked me several questions, and I'm going to take his first major question first, and then if I have time, I will take the rest of them. But the first question I'm going to take is from one of my most frequent questioners over the months, Terry Alther. Terry asked me, sorry to add the mic in on that new software. I'm still learning how to do some of this stuff. Question for first Wednesday today. I was looking back at the Hollingsworth versus Perry decision on Wikipedia. Always a dangerous thing to do, to try to get your legal knowledge from Wikipedia. When I noticed that Scalia and Roberts believed with the majority, this is the same-sex marriage case. Hollingsworth versus Perry was the one that decided the fate of Proposition 8 here in California, which was Proposition 8 was what happened in California was that the Supreme Court of California decided that the California Constitution required recognition of same-sex marriages under the California Constitution's Equal Protection Clause. Despite this proposition that a law that had passed by proposition that outlawed same-sex marriage. So then a constitutional amendment was passed, and that was what was found unconstitutional by the Supreme Court. And so, the constitutional amendment was Prop 8 that was supposed to overturn the decision of the California Supreme Court, and the proposition passed, and then there was a lawsuit against the proposition. I'm sorry, there's sort of a long discussion here, but so anyway, what Terry Alther is asking about that decision is, while Kennedy and Sotomayor disagreed, even though they were for same-sex marriage, I'm not sure why, that the majority found they had no standing. So, and let me see if I can explain this in a fairly short, easily understandable way. Like I said, there was a proposition passed in California that outlawed same-sex marriage, and that proposition amending the California Constitution was overturned by the California Supreme Court. The governor and the attorney general of California did not want to fight that decision. And so the people who started the proposition, they were the ones who sued to say, you have to let our proposition be enforced and stop same-sex marriage in California. And what the Supreme Court decided, they didn't decide whether same-sex marriage was a constitutional right or not. Instead, what they decided was the people who were suing, the people who passed this proposition, they didn't have a right to appeal the lower court, federal district court ruling that said that the proposition was unconstitutional, because it was on what's called standing, the issue of standing. People can only sue if they're harmed, if they have a special harm from a law, and these people didn't have any harm any more special than anyone else. And because the state of California didn't want to sue on behalf of the proposition, the people who were suing to try to uphold the proposition banning gay marriage didn't have standing to do it. So the question is, so Scalia and Roberts believed that with the majority that they had no standing, even though they are against same-sex marriage, while Kennedy and Sotomayor disagreed, even though they are for same-sex marriage, though I'm not sure why. Therefore, was the court only allowed to look at the standing requirements? And the answer to that first question is yes. Standing is the first issue. If a court does not finds there's no standing to sue, then it doesn't get to the merits. It never decides the constitutionality of the case. It only says no standing, we dismiss. And by the way, the thing you said there about that that Kennedy was for same-sex marriage, that's kind of up in the air. And then after the question, was the court only allowed to look at standing, the next question is, why did Kennedy and Sotomayor disagree with the majority? And so to answer this question, first I want to show you something from the majority opinion. Jurisdiction to hear cases. So if you don't have Article 3 standing, you can't sue. So why was it that Kennedy and Sotomayor disagree? Why were they on the other side? Well, Kennedy wrote a dissent, and exactly why Sotomayor agreed with Kennedy, she never wrote anything, so we can just assume she agreed with what Kennedy wrote, and what Kennedy wrote, why he thought there should. So basically, they're saying that if the purpose of the initiative process is for the people to be able to pass laws that the government officials don't like, but then if those laws are struck down, only the government officials can defend them, then it doesn't understand what's going on in the initiative process. And you can see how that's not like really a traditional left-right issue. The whole standing issue doesn't divide justices like Republicans and Democrats. Wait. I just noticed I didn't turn the microphone on when I had those other. I'm really sorry about that. So the reasons that first, let me show you again with a microphone. This is the reason that the majority held that there was no standing. We have repeatedly held that such a generalized grievance, no matter how sincere, is insufficient to confer standing. A litigant raising only a generally available grievance about government, claiming only harm to his and every citizen's interest in proper application of the constitutional laws, and seeking relief that no more directly and tangibly benefits him than it does the public at large, does not state an Article 3 case or controversy. And Article 3 is the part of the U.S. Constitution that gives the Supreme Court jurisdiction to hear cases. So if you don't have Article 3 standing, then you can't sue in federal court. And the reason that the dissent disagreed, Kennedy and Sotomayor, and hold on, I'll turn the microphone on here. Yeah, so you can see they say the court's reasoning does not take into account the fundamental principles of the practical dynamics of the initiative system in California, which uses this mechanism to control and to bypass public officials, the same officials who would not defend the initiative, an injury the court now leaves unremedied. So, yeah, what they're saying there is that the whole purpose of the initiative process in California is to give the people the ability to pass laws that government officials don't necessarily like. But if then those laws are struck down and only government officials have standing to defend them, that totally misunderstands the whole purpose of the initiative process. So anyway, sorry I said that twice there because the first time I didn't have the microphone turned on. So I'll go to the next question here, turning on the microphone. And now I have turned on the microphone. And the question from Leo G is, if a mere moment of silence for meditation or voluntary prayer in public schools is unconstitutional, Supreme Court of the United States 85, how can it be constitutional for members of government to open meetings with overt prayer? I'm sorry, I'm going to quick. The reason, the differentiation for that is between children and adults is one of the main reasons, and also people who have to be somewhere versus who don't have to be. I'd say those are the two main distinctions between prayer in school and prayers at government meetings. There's actually a case here, Marsh versus Chambers from 1983 here, that basically took on the question of whether Nebraska could open its its legislative meetings with a prayer, and found yes, they could open it up with a prayer. And basically the reasoning was that, and if I were a religious person, this would kind of upset me that this is the reasoning, but the reasoning is that it's I don't think they use the phrase ceremonial deism in that decision, but that's kind of the concept, that it's historical, it's a nod to history and to ritual and has no real religious significance. And so if I were a religious person, I'd be kind of offended saying that the prayer has no religious significance, but that is basically what you have to believe if you want to go and follow the Supreme Court. At least that decision from 83, the excuse me, the issue is actually up before the Supreme Court again this term. What is it? Greece versus Galloway. It's a local town meeting, and they're gonna take up the issue again. And I wouldn't be surprised to see the same thing, that that historical ceremonial deism doesn't have any religious significance, and so doesn't violate the Establishment Clause. That's kind of what the reasoning is. So let me go to the next question here. Pollock Fury says, why would Elizabeth Warren state that she is native background when even natives know she isn't one? Well, I think that's actually kind of a loaded question. I'm not sure that it's even been proven whether Elizabeth Warren has Native American heritage. I'm no expert on Elizabeth Warren. I don't live in Massachusetts. I do like a lot of things about her, and I heard Fox News harping on the whole Native American controversy thing, but from what I saw when I looked into it a little bit, it seemed like she was always told growing up that she had some Native American blood, and it wasn't like some official thing, but it was just like some family history that she had been passed down through her like grandparents and parents. But there's not any tangible evidence or real proof of her Native American heritage. But that part about whether that's something that even Native Americans know she's not Native American, I'm not sure if that's actually true. But anyway, so I don't know if that's a acceptable answer, if that's a satisfactory answer for the question. Probably not, but that's my answer anyway. So let me look at. Okay. Each time I'm loading these up, I have to remember to turn the microphone on, so I did that again. Harvey Cotton asks, how can revenue bills pass the Senate first? Does that contravene the Constitution? And that's from Article 1 of the Constitution. One of the things it says that revenue bills have to originate in the House of Representatives. They can't originate in the U.S. Senate. But that has been construed really narrowly by the Supreme Court as to exactly what a revenue bill is. There was one big case on it. It's a U.S. versus, I think it's Munoz Flores, MUNOZ-FLORES. And I have a little excerpt from it here. Saying a statute that creates a particular government program and that raises revenue to support that program, as opposed to a statute that raises revenue to support government generally, is not a bill for raising revenue within the meaning of the origination clause. I actually thought about this when it came to Obamacare, the Affordable Care Act, because it was passed in the Senate first. The bill that eventually became law was based on the bill that passed the Senate first, and it was found to be a tax by the Supreme Court. So I was thinking, does that mean that someone could challenge it under the origination clause? That was like an idea I had back at the time that Obamacare was found constitutional. But that's actually when I first looked up and remembered this Munoz Flores case that said basically unless it's like a rise in the income tax, or it's a bill that just raises revenue and doesn't do anything else. I mean, I hope that answers the question here. From Harvey Cotton, he didn't say exactly what bill he was thinking about. Maybe he was thinking about Obamacare, because that's what raised the question for me. So I don't know if that answers the question for what bill he was thinking of, but let me see here. I've got a question here from Patrol 213. Says, in 2016, if there are any third-party candidates and if these people are in a debate, would you like to be informed about them? That seems like a pretty easy question. The answer is yes. I think that the requirements to, and I'm not sure if you're talking about when you ask it to what I want to hear about the debates. Do I want to hear about third-party candidates and fourth-party candidates debating each other, or do I want the third-party candidates to be in the main debate? And I would like to see more candidates in the main debate. Although sometimes I think it would be good to have a mix. I remember back when Ross Perot was in the debates with Bush and Clinton, and the first Bush, and that was kind of an interesting format. On the other hand, sometimes these like the primary debates where they have like 7-8 candidates on the stage, it can sometimes not be as informative as when you can see one or two or three, or two or three people right up against each other more. So I do have some worries about that, but let me go down here. I think I have, was it one more? Let's see, is this the last one I did? Let me look here real quick. Oh, yes, I said if I had a little more time, I would come back to Leo G, and his next question was, what is the legal definition, interpretation of tangible, as in Patriot Act Section 215? By that definition, what is excluded, and does this explain why only metadata are supposedly collected? On the last question, no, I don't think it has anything to do with metadata. I did want to show, this is from the Center for Constitutional Rights here, has a fact page about the Patriot Act. In Section 215, any tangible things may include almost any kind of property, such as books, documents, and computers. The FBI may also monitor or seize personal records held by public libraries, bookstores, medical offices, internet providers, churches, political groups, universities, and other businesses and institutions. So basically, it's anything, and it could be, it could be the text to the email is just as much as the metadata. The reason the metadata over the content is taken has more to do with when you listen to the content, that's wiretapping. But then there's this case, the Maryland versus Smith, or is it Smith versus Maryland? It's either Maryland versus Smith or Smith versus Maryland from the 70s, where they put what's called a pen register on a telephone line at the phone company. And this is also the third party doctrine, where once you give information like your call, the metadata information, the time of the call, and who you're calling, when you give that information to the phone company, you no longer have a reasonable expectation of privacy in it. But the content of your conversation, that's actually protected by wiretapping law. And in fact, FISA, the Foreign Intelligence Surveillance Act, is a specific exemption to anti-eavesdropping laws that say you can't listen in on the content. So that's the answer to that question. I will get to one more preloaded question. And the last time I have to turn the microphone on. It says, recent reports and documentaries such as Unmanned Drone Wars portray U.S. drone strikes as terrorism. Should there be a UN or other independent legal review of the U.S. drone program? Well, as much as I don't like the drone program, I'm not sure it really fits a definition of terrorism. Of course, it depends on what your definition is. Um, I generally think that you have to be targeting civilians for to make to persuade people with force. And while the drones have a lot of collateral damage that hits civilians, they're actually supposedly military missions. Uh, for example, and I made several videos on this over the years. One about the Fort Hood shooter. What's his name? Can't even remember his name anymore. But he was recently found guilty, and about whether shooting up a military base might not be terrorism because it's not a civilian target; it's a military target. Also, on 9/11, the attack on the Pentagon. Except it used a civilian airliner, so I suppose in some twisted way you could call them collateral damage, but at least the attack on the Pentagon without the other issues, you could consider that not to be terrorism because it's a military target. And conversely, I made a video about the definition of terrorism a while back, talking about whether the United States bombing of Hiroshima, that could be considered terrorism because it was basically targeting a civilian. And the same thing with the firebombing of Tokyo and Dresden. So it doesn't just have to be an atomic bombing, but where you're targeting civilian populations and trying to use force to like change their political opinion. That's what terrorism is. But the targeting civilian parts, I think, is necessary, and that doesn't mean that I think the drone program is legal. I'm just not sure if it's terrorism, and I do think there should be legal review of that. So anyway, those are the questions I had loaded up before I started, and I'm actually I started late, so I'm at about 23 minutes now, and I'm sorry about the software problems, but oh no, it doesn't. Okay, wait, let's see. Let me see. Yeah. Oh yes. Can't hear you. No sound when you switch over. Not getting sound during clips. When you put up graphics, sound goes away. You're cutting yourself off. And there's the Apollo. Okay, so I guess from like 16 to 12 minutes ago. Let's see. DJ Pobs after that said, that's the same thing preventing the ACLU from suing for NSA spying, isn't it? And I think the standing issue, and that's true, although the latest lawsuit, that is why a big lawsuit that the ACLU was involved in, where they got a bunch of journalists and human rights workers to sue about NSA spying because they did a lot of international calling, and they said that they couldn't talk to people freely. Their First Amendment rights were chilled, and they were worried that they were being listened to, and these cases were dismissed because for lack of standing, because they didn't have any injury any worse than anyone else. Even though the ACLU tried to get together a bunch of people who would be particularly injured by eavesdropping on international conversations, they lost on standing issues. But now the latest ACLU lawsuit, since this Edward Snowden leak, like a week after that came out, where it showed that they'd been collecting all of the phone records from Verizon. They had the actual order was leaked as part of the Edward Snowden leaks. The ACLU came out with a lawsuit where it actually says, hey, we at the ACLU, we use Verizon. We use Verizon for a lot of our calls. So now we have standing. We have been specifically injured because our metadata has been collected. So we'll see how that new lawsuit, the latest version of ACLU versus Clapper. Let's see. See, Steve Enever says, I've heard that Vermont is going to single payer in 2016 and that this was from a clause in the Affordable Care Act. Any thoughts? Well, I know Vermont covers like all of the children and has some of the best coverage, but I actually don't know specifically about how that relates to the Affordable Care Act. In California, we've had some bills that would make California go single payer, and I think single payer is definitely a better way to go, and some of the problems that have been happening with Obamacare kind of prove that. Certainly that there should have been at least a public option, but and then this sounds sort of related. Danny Ledwith 21 asks, how do you respond to the notion that the government is inherently inefficient since there isn't any competition or profit motive like you see in a competitive market? Well, I mean, there's definitely something to that. I agree with part of that, that the profit motive does create certain efficiencies in the private market that you don't see from government work, but that assumes, first of all, that profit is the highest value and that the profit motive is always going to get you where you want to go. And I don't think those are always true. They're true for a lot of things. That's why I do believe in a basically capitalistic system. I'm not a socialist or a communist, although I know every time I'm surprised. I said something negative about communism in one of my videos recently. And I got all these comments about, you don't understand, communism isn't that bad. And so I guess that tells me a little bit about my viewership. But yeah, no, I'm not a socialist or communist. I believe in what I would call mixed capitalism, capitalism with a important social safety net where you make sure that people don't go hungry or, if possible, without shelter, that they're, minimum wage, and also I believe in universal health care. I don't think any of those are incompatible with capitalism. And in fact, the profit motive is not really the best motivator in the health, because the transaction that people undergo in healthcare isn't like a lot of transaction. First of all, the need is very inelastic. When you need healthcare, you're not really in a place to be bargaining on for price. I mean, getting health insurance maybe, but and it's also very difficult to foresee exactly what your needs are going to be. That's why it has to be insured, and the motivation of insurance companies is really perverse, because once they've sold you the insurance policy, their motivation is actually to minimize your usage, to find every way to turn you down and cut you off. And so I mean, in that sense, there are some real difficulties with the profit motive in a healthcare system. So I do believe that government is less efficient than the private market in a lot of ways, and that the competition and the profit motive is a much better driver of most economic activity than socialism or communism. But I do think that the government has a role to play, and healthcare is one of those places. Let me see. It looks like I'm almost at the 30-minute mark, and DJ Pob says, just out of curiosity, have you read the Communist Manifesto? Yes. Marx, Engels, yes. We have nothing to lose but our chains. And there's some things about Marx and dialectical materialism. There's some really good concepts in there. I mean, not the system itself. And, that's one of the things I've noticed. People on the right, the labor theory of value, which that actually, I think it was David Ricardo first came up with that. But the way he used the labor theory of value, and I mean, there's some really, and some good ideas in the Communist Manifesto, just the dictatorship of the proletariat and the melting away of the state, that part, and and of course Leninism and Stalinism and the way it was implemented in the Soviet Union. That's a whole other thing. But anyway, let me see. Oh, Stalin was a saint. See, I don't know why someone would say Stalin was a saint. That is not something I'm ever going to agree on. In fact, I made that point in a video because I studied, I was a history major, and I did my senior essay on the attempt at the international control of atomic weapons at the end of World War II. And and I made a video about that. I think it was called No More Nukes. And I talk about Stalin and how Stalin was kind of a megalomaniac and paranoid, and how even though the United States did all these bad things that made the international control of atomic weapons not really possible, even if the United States had done everything right, I'm not sure they could have made a deal with Stalin anyway. So is that sarcastic? Dude, Stalin was a saint? I hope not. But anyway, so I'm sorry about the slight technical problems there where I put up some graphics, and I'll try to I'll put in a link when this is a recorded show so people can skip over that. I hope it didn't end up being too disjointed for the people who are watching live. Thanks for joining me. It's looking more and more like I may not be able to do the regular Liberal Viewer Sunday live clip roundup this Sunday because I may have to go into San Francisco. So I may do an abbreviated show or put something else up. And of course, I'm still working on this video, Obamacare forces corporate abortions, question mark, that I don't know, maybe I'll have that up on Sunday or maybe before, depending. I don't know. It's been a very hectic week with all sorts of stuff going on, but I appreciate all of you joining me. I noticed I got a couple dozen people, so my core viewership who like to just listen to me talk on and on, even more than I may like to do it myself. So thank you for joining me. Have a good rest of your week, and one way or the other, I'll have something up for you to watch on Sunday, and that should do it for Liberal Viewer First Wednesday Live. Till next month, next year, the first Wednesday of the month at 4:30 p.m. Pacific.